Good afternoon, everyone. My name is Melissa Andre. I'm the Executive Director of the Philadelphia Tax Review Board, and today is Thursday, May 8th of 2025. We are convening a session of the Philadelphia Tax Review Board, and today's category is License and Inspection. With me today is our Acting Board Chair, John O'Connor, as well as board members George Matthews, Ryan Boyer, and Nancy Camerdiner. I am recording this as it will be posted on the Tax Review Board's website. I'm also supposed to tell everybody to please be aware that this is a public hearing and it is being recorded. Because the meeting is public, participants and viewers have no expectation of privacy. And by continuing to be in this meeting, you are consenting to being recorded. This recording will be posted on the Tax Review Board's website. John, please take it away.
Yes, good afternoon, everyone. It's John O'Connor here, the acting board chair today. I believe the first case we're doing today is case number 1. And the last 4 digits ending in, it looks like 3110Z, John Ciferni, and that address is 230 West Wildley Street. And it's my understanding there is no action needed on this case today.
Ms. Stiles?
Yes, that is correct. The bill that was originally appealed has been withdrawn. So there is an agreement. There is no action needed on this.
All right. Do we need a vote on that?
Yes.
All right. Board members, can I get a concurrence on that?
Nancy Camerdiner, I concur.
Ryan Boyer, I concur.
George Matthews, I concur.
John O'Connor, I also concur. All right. Can we move on then to case number 2?
Yes.
All right, case number 2, last 4 digits ending in 6TEZ, Sylvester Barnes. And address there, 2569 North Stanley Street. And again, on this matter, my information is there is no action needed. Counsel?
I'm going to jump in here, Ms. Stiles. I've spoken to Ms. Stiles as well as Mr. Barnes. This is not the case he wanted to appeal. He heard this clip matter as well as the demolition matter at the same time. And unfortunately, he submitted the appeal documentation for the wrong case. His intention was to appeal the demolition matter. I've spoken to Mr. Barnes. He will be submitting the proper appeal for the demolition, but he did not intend to appeal this clip matter. Ms. Stiles?
And that is my understanding as well. So I have no objection or anything else to add.
So we should
Okay.
mark this one as no action needed as well.
All right, can I have concurrence from the board, please?
Nancy Camerdiner, I concur.
Ryan Boyer, I concur.
George Matthews, I concur.
John O'Connor, I concur. All right, let's move on then to case number 3, the last 4 digits ending in 4206, 1355-57 North 2nd Street, Philadelphia. And it looks like this case has been withdrawn. The settlement has been reached.
That is correct. That settlement was reduced to writing, signed by both parties. A copy was emailed to the board, and as part of that settlement, the appeal was withdrawn.
Okay, thank you, counsel. Is there any need for a vote on this?
No, it was already withdrawn.
Okay, great. Right, let's move on to case number 4. And that would be 2320 North 50th Street, Philadelphia, PA 19131. And my information is that case was also withdrawn and a settlement reached in that matter. Counsel, can you comment on that, please?
Yes, correct. The bills at issue here were actually paid by the petitioner, and they withdrew their appeal.
Okay, thank you very much. All right, that would take us, are we doing case number 5 next, Melissa, or 6?
Yeah.
I'm sorry.
Hold on one second.
I believe it's
Okay.
6.
Okay.
Case 6.
Timed out. Just hold on. The computer timed out and we just need to log back in.
Okay.
Can you log in? All right. Here we go. Mr. Harris, or is it Mr. Brown? Brown, I'm sorry, Mr. Brown, come on in.
How you doing, sir? How you doing?
I'm good. How are you today?
Good.
This is Mr. Brown. This is the board. Just keep your voice nice and loud, okay?
Okay.
Thank you.
Good afternoon, Mr. Brown. I'm John O'Connor, the acting chair today. Can you please raise your right hand and state your name and address, please?
Tyrone Brown, my address is 1061 Flanders Road.
Okay, do you swear or affirm to tell the truth today
Yeah,
with the issues before the board of the Tax Review Board?
yes,
All right, thank you. All right, this, for the record, is for the last four digits is TX, excuse me, X44, maybe L, it looks like. And the address is 514 North Hodges Street, Philadelphia, PA 19131.
yes.
Okay. All right. Counsel for the city, do you want to make an opening statement for this matter?
Yes, thank you. Amy Skiles, Skiles, on behalf of the city of Philadelphia. It's the city's position that there are a few jurisdictional defects that will prevent this case from being heard in this forum, the Tax Review Board. First, just to provide some factual background, this is an appeal from a clean and seal abatement, which was performed November 18th in 2013. The bill was sent December 10th of 2013. The petitioner here, who is here today, did not purchase this property until roughly 6 months after the abatement and the bill was sent. The petitioner purchased this property May 29th of 2014. And this instant petition was filed nearly 10 years after that purchase on April 17th, 2024. So it's our position there are a few reasons why this petition should be dismissed. The first is that Mr. Brown does not currently nor has ever had any personal liability for this bill. Per the code, the Tax Review Board has jurisdiction over the liability of any person. As this bill was not sent to the petitioner and he was not the owner at the time of the abatement, he is not personally liable for this bill. Therefore, the Tax Review Board has no jurisdiction to act over this petition. Since there was no timely appeal filed for the bill, this bill was converted to a lien and indexed as a lien. This is an in rem lien that attaches to the property, not Mr. Brown as a person. And the Court of Common Pleas is the exclusive venue to challenge this lien, meaning Mr. Brown may have a remedy. However, that remedy is with the Court of Common Pleas and not here at the Tax Review Board. So for that additional reason, we believe that the Tax Review Board does not have jurisdiction to hear this petition. And finally, this petition was filed very untimely. Under the code, a petitioner has 60 days to appeal a bill. It is the petitioner's burden to prove that they are entitled to hear, that they're entitled to nunc-pro-tunc relief. The petition here simply states, I cleaned out the property. It doesn't give any reason for a late filing. The owner, the petitioner, Mr. Brown, owned the property for over 10 years before taking an appeal. It was Mr. Brown's responsibility to discover this lien for a long time ago. Years ago. And because it's taken 10 years for Mr. Brown to file this appeal, the city is extremely prejudiced with this delay. We have very, very limited records left about the original abatement. There's been no reason or justification as to why this untimely appeal was so untimely. So for those three reasons, that there's no personal liability, that this is an in rem lien, and that it was a very untimely appeal with no justification given, we would ask that this petition be dismissed.
I do have a
It's a-
question, Ms. Kyle. I'm sorry. When was the in-rem lien filed, or do we have a date?
I don't have the date exactly, but I do have the lien number if you would like the number.
Sure, because I think it also is by date. There's a year in that lien number.
Just give me one. So that lien number is 140102554.
And then can we read the numbers in for the record? John, can you?
Yes, yes, the lien number is 1401025 for the record. Okay. All right, Mr. Brown,
Yes,
John, the numbers for the record.
I'm sorry.
The numbers for the record, Ms. Fonseca.
Oh, I'm sorry. Yes,
My apologies. So
yes,
the-
yes. Could you please state your name and address and your position with the city, please?
Hello, I am Eileen Fonseca. I'm one of the supervisors here with the Litigation Support Unit, and I am providing the numbers for the actual bill referencing 514 North Bodger Street.
Okay. Do you swear or affirm to tell the truth today in this matter before the Tax Review Board?
Yes, I do.
Okay. Thank you very much.
So this is the clean and seal abatement bill. The bill date that we have on record is December 10th of 2013. Bill number is 001245261. Principal amount is $2,310.61. The administrative fee is $485.23. And the interest in which accrued is $1,606.65, totaling out the lien to be $4,402.49.
Okay. Thank you. Mr. Brown?
yes,
Yes, you've heard the testimony of the
Mhm.
counsel for the city in terms of why this, why your petition should not proceed today regarding, the fact that it's been filed 10 years after the fact, and the fact that you had no personal responsibility for this, the clean and seal, or, the work that, was done here. What is your response to that, sir?
I didn't get the bill. First of all, how's everybody doing? I didn't get the
Good.
bill for how much it was until last year late. I didn't get the bill till last year late. I didn't bring all that with me, but I got it late.
Can
The
I ask
second
you,
thing,
can I
got
ask you a question, Mr. Brown?
correspondence. Pardon?
Mr. Brown, I'm sorry, I don't mean to cut you off, but I wanted to ask you a question. When
Mhm.
you settled on the property, did you go to a title company to do that?
Yeah, it wasn't there. It wasn't there. It wasn't there at all. So that's why I bought the property. I bought it free and clear. That's what I thought. Okay, so that's my whole thing. I don't think. Now, let me share this with you. Okay, I was the Bateman Service Supervisor at License Inspection Clean and Seal. When they cleaned that building, I was their supervisor. Okay. When I bought the building and when I went in the building, I seen all that trash, but I had retired by then. Okay. I retired by then. When I went in to see what's in the building, you understand what I'm saying? It was trash in there. I'm not saying they didn't clean anything. I'm not saying that, but they didn't clean $4,000 worth of stuff. That's my argument. If I have to pay something, I don't want to go back and forth about it because I just don't want to. That, be honest with you, I don't want to go back and forth about it. All I'm asking the court is to knock some of this money off so I can pay you guys and I can move on. That's what I'm asking for. All right, I'm not asking for nothing else. I've worked on the clean and seal all the time. I used to come down here sometime and challenge the bills when I was a sub crew chief. You know what I mean? So I understand all that. We really get hyped to come down here to try to win the bill, win the case. All I'm asking for is mercy of the court. I can get some of this knocked off. I can pay this bill and I can move on. That's it.
All right.
You want to
Thank
go
you,
to the
sir.
back, John?
Yes, I think we should go to the other room and discuss this matter.
Thank you.
I mean, she has, but she's not being picky. I'm gonna star it when I go to do. I got this shit to do. That's more pressing. These financials are burning. This is for this. I need to check. I thought I paid this year. Hello.
Missed your call, what's up?
Hello.
It's Mitch.
Why does he keep on unmuting himself?
All right, is everyone back?
Yes, now everyone is back.
All right, again, John O'Connor, the acting chairman. And Mr. Brown, we certainly feel your pain, but unfortunately, we're not going to be able to touch this matter because it's really been way too long. It's been 10 years. And you really have no personal liability for this. So we really can't do anything. It would have to be something done with the Court of Common Pleas because there was a lien filed and it was recorded prior to you purchasing the property. I mean, you may have an issue with your title company, but there's nothing we can do right now with this. So we're going to have to dismiss your petition. We're gonna have to find against you. I'm sorry. Do you have anything you'd like to say?
Who do I have to see now? The Common Pleas Court or something?
Yeah, that would be one venue you could go to. You can actually file, you have a right to file an appeal within 30 days, either side, to the Court of Common Pleas regarding this matter. Or maybe check with the Court of Common Pleas regarding the lien itself in the interim to see if there's something you can do about that. Okay? But there's really, we just have no jurisdiction here at this point, unfortunately. All right, can I have concurrence from the board?
Ryan Boyer, I concur.
Nancy Camerediner, I concur.
George Matthews, I concur.
John O'Connor, I also concur. All right, sir, again, you'll be receiving a letter within a couple of weeks regarding our decision. It'll indicate on there you have 30 days to file an appeal if you want to. And at that point, it's up to you what you want to do. But I would suggest you try to follow through with the Court of Common Pleas with either checking out the lien itself or maybe if you want to file an appeal, okay?
Okay, I just want to be clear on why. You said because it was filed and I didn't get it. And what was the other reasons?
Just the length of time. And also the fact that you have no personal liability for this lien, for the work, because it was never issued in your name.
And ultimately, the tax review board does not have jurisdiction because it is liened.
All right, sir.
All right.
All right. Well, good luck.
Need
Take
to
care.
know what I have to do from this point.
Pardon me?
I said, I just wanted to know what I have to do from this point.
Sure. Okay.
Mhm.
You just follow through with the, once you receive the letter, you can file the appeal with the Court of Common Pleas. Or I said, prior to that, maybe check out the lien itself and to see if there's anything you can do to have that removed. See what you need to do to, have that removed. Maybe you can negotiate with the city. All right?
Have it removed.
Yes.
I know, okay, I don't want to argue the case. I don't.
All right. All right. Well, thank you, sir, for coming in.
Yeah.
Take care.
Thank you.
Have a good afternoon. Bye.
Yep.
All right, I guess we're going to move on to case number 5.
6. Oh, yes, no, 5, you're right.
Thank you. I believe we have Mitchell Ripken in the waiting room.
No, he's right here on Zoom.
Oh, he's on, that's what I mean, I'm sorry. In the waiting room on Zoom, that's what I meant.
You can call it. He's ready.
All right, yes, this is case number 5, which is 1918 South 23rd Street. Looking for the digit numbers here. I had them written down, but now I can't seem to find them.
E8WZ.
Say that again?
E8WZ.
All right, I see it now. It's 4-digit number E8WZ, again, 1918 South 23rd Street. And we have Mr. Mitchell Ripken here.
Good afternoon.
Good afternoon, Mr. Ripken. My name is John O'Connor. I'm the acting chairman of the board today. Could you please raise your right hand, swear or affirm to tell the truth today regarding this matter before the board?
Right hands up. I swear to tell the truth during this matter with the board.
All right, thank you, sir. All right. All right, we're going to probably start out with the city here, City of Philadelphia. Can we state the matter at issue here?
Good afternoon. Oh,
Yeah.
I don't know if you want me to read the numbers.
Yes.
Good afternoon. This is for the property at 1918 South 23rd Street. This
Want to
is
hear
for
it now?
for a code enforcement reinspection fee. Bill date is April 23rd of 2024. Bill number is 2024-001210. Principal amount is $100. No administrative charge, no interest, no penalty, just $100 even.
Okay. Counsel, do you want to put a case on, or you want to go back to Mr.
Yes,
Ripken?
I do, I'll present some exhibits and some brief testimony
Okay,
through
thank you.
Ms. Fonseca. Okay, and if I may have permission to share my screen.
Hold on 1 second. We're doing this a little backwards because I think, do you have an opening? If not, the defendant has the burden. I mean, the petitioner has the burden.
Oh, just a brief opening. Okay, just briefly, as Ms. Fonseca stated, this is about a reinspection fee. The code is pretty clear. The code sets forth the amounts and when those reinspection fees can be charged. Here, you will hear later through testimony that a notice of violation was issued in January of 2024. That property was reinspected March 11th of 2024 and April 12th of 2024. It was eventually re-inspected again on April 23rd, 2024, at which point it was complied. But during that time, there was one fee triggering re-inspection that took place on April 12th, 2024. So it will be the city's position that it was entitled to charge Mr. Ripken a $100 re-inspection fee that took place on April 12th of 2024, as notice was properly provided of the NOV. And that would be the city's opening.
Okay, thank you. Mr. Ripken, would you like to say something?
Sure. Situation was, I'm a landlord. That's what I do for 50 years. My office is around the corner from all my properties. I take care of business immediately. Okay. I never got noticed. I didn't get noticed. The only reason I found out about the violation was because I was getting a certificate of suitability for the next tenant, and they wouldn't give it to me. Therefore, I called L&I, and I tried very hard to get a copy of the notice, and they refused to give it to me. Now, when I first asked where the notice was sent, they told me it was sent to my old office in Southwest, whereas on my rental license, it's very clear where my office is. Again, I never got notice at all. Number two, as soon as I found out about it, I fixed what I could. Now, the notices were ambiguous, and it mentioned three windows in the basement. And I did fix three windows. What ended up happening was there was a fourth window that was covered by a heat duct, a large heat duct, and I had to duck down and look behind the heat duct to find it. So though I did fix the three windows, no one was able to come out and show me. Finally, when the inspector came out to do a final, everything was done, but I didn't know which. He pointed to a window behind the ductwork that I wasn't even aware was there. So because of I was unable to get photographs from the violation people. People holding the violation refused to send me pictures, refused to give me information, refused to let me come down and pick it up. So I was at the bird. What do you call it? I tried my best to do this, and it's really not about the $100. It's the point that I did nothing wrong, and they never mailed it to me. Besides, they never mailed it to me again. I'm telling you, they refused to send me the information when I asked for it. I did the best I could.
What was your office address at the time?
1717 Montrose. When I asked them where they sent it to, they told me 6830 Buist. I've been out of there for over 15 years. And the address on my rental license is 1717 Montrose, and it never came.
Okay. When did you first contact L&I?
Probably after the second inspection, I knew of the violation by accident, by looking to get a certificate of suitability. That's how I knew about it. Nobody contacted me. I contacted L&I after
Do you recall when you applied for that or tried to attempted to get the suitability?
It was prior to the third inspection.
Prior to the third, but after the second, right?
I didn't know about the first two inspections.
Well, I mean, you testified prior to the third inspection.
Pardon me. I had access for the third. At that point, he showed me which window it was, and when I finally, it's the violation said three windows. It didn't spell out which three windows. It said three windows, and I fixed three windows.
Okay.
And when he showed me the window, I said, "Oh, you know what it was? There was nothing wrong with the window. It just wouldn't operate correctly, according to his opinion. The window wasn't broken, unless I had never tried to open it. So then, once he showed me, I fixed it, and that was the only thing he had to come back to see."
Okay. Do you have anything else, sir?
No, I'm done.
Okay. All right. Thank you. City?
Yes, the city, once again, Amy Skiles on behalf of the city of Philadelphia. I would call Ms. Fonseca briefly for some testimony.
Okay.
Good afternoon.
Good afternoon again. Have you already been sworn in? So begin your testimony.
So, Ms. Fonseca, could you just state your position with the department?
Currently, I'm the code administrative supervisor for the litigation support unit.
Okay. And what are some of your roles and responsibilities with the department?
Pretty much overseeing tax review board, the right to know requests, also municipal and equity court. Also prior to that, I was an inspector, a field inspector for at least about 5.5 years.
Okay. So you're familiar with how violations are issued, how NOVs are mailed throughout the course of your duties?
Yes.
Okay. And also throughout the course of your duties, did you have an opportunity to familiarize yourself with the case file for 1918 South 23rd Street?
I did, yes.
Okay. And with the board's permission, I would like to share my screen.
Okay.
I'm gonna pass City Exhibit 1 and 2, which were the deed and the address maintained with the Office of Property Assessment. But through Mr. Ripkin's testimony, he has already admitted that 1717 Montrose Street is a good mailing address. So I will go right to City's Exhibit 3. So Ms. Fonseca, did the city have an opportunity to inspect this property in January of 2024?
They did, yes.
Okay, and City Exhibit 3, are these a collection of photographs that were taken at that inspection?
Yes.
Okay, and I believe I will scroll down. I'm looking at City Exhibit 3, page 11. Does this highlight one of the issues with the windows?
It does, yes.
Okay. And this photo here, does this also highlight another issue with the windows?
Yes, it does.
Okay, and then further down here, what specifically is wrong with this window?
It's boarded, and there's no window there.
And is that permissible under the Philadelphia Code?
It is, yes.
Being boarded and sealed, that's allowed?
Oh, no, it's not. It's not. I'm sorry. It's
No
not an
problem.
occupied
rephrase.
property, no.
I'll rephrase my question. This photograph, does this depict a violation of the Philadelphia Code?
It does, yes,
Okay.
it is.
Okay. And here you can see it appears the window was also sealed from the interior as well?
Yes.
Okay. So now I am going to scroll down to City Exhibit 4. Ms. Fonseca, do you recognize this document?
Yes.
What is this document?
This is the initial notice of violation, pretty much stating what the inspector had found during his inspection.
Okay, and what is the date of this notice?
Date of notice is January 6th of 2024.
Okay, and where was this notice mailed?
Was mailed to the violation property at 1918 South 23rd Street.
Okay, and it also indicates the items in violation of the code that were cited.
That's correct, yes, it does.
And based on your review of the photographs, these violations were properly issued?
Yes.
Okay, so I'm going to scroll down. And if there are multiple addresses of record, does the department often send more than one notice of violation to multiple addresses?
Yes, we do.
And was that done here in this case?
Yes.
Okay, so I'm now gonna move on to page 18. What is this document?
It's the same document as the first, which is the notice of violation, the initial notice, and this was sent to the 6830 Buist Avenue address.
Okay, I am now going to scroll to page 21. What is this document?
Again, another, well, not duplicate, but it's another notice of violation. Same violations in which were issued in January 6th of 2024, sent to another address at 1717 Montrose Street.
Okay. And then finally, I'm going to scroll to page 24. And what is this document?
Another copy, again, of the initial notice of violation that was issued in January, sent to an address in Royersford, Pennsylvania, 341 10th Avenue, Suite 200.
Okay, so in this case, the department sent the notice of violation to 4 addresses.
That is correct, yes.
And one of those was the address that's maintained by the petitioner, 1717 Montrose Street.
Yes.
Okay. And so after this notice of violation was issued, did the department conduct a re-inspection? Or let me back up. To your knowledge, was this violation notice ever appealed to the Board of License and Inspection Review?
No, it was not.
Okay. And City Exhibit 5, this is just a printout from the city's record showing that no appeal had been taken. Okay, and so after the notice of violation was issued, did the department re-inspect the property?
Yes.
Okay, and I'm gonna direct your attention to City Exhibit 6. This photograph was taken March 11th of 2024. Was this taken on the department's first reinspection?
This was, yes, the first reinspection.
And what did the department learn when they conducted this reinspection?
They verified if the violations were still in violation, which they were, and so it automatically failed the case.
Okay, and then did the department go out again for another reinspection?
Yes,
And directing your attention to City Exhibit 7, what was the date that this photograph was taken?
this was taken on April 12th of
Okay,
2024.
and this was taken on the department's second reinspection of the case file.
That is correct,
Okay.
yes.
And what, if anything, did the department learn when they conducted this reinspection?
2 of the 3 violations in which were issued were actually in compliance on this day, on April 12th of 2024.
Okay, but one remained,
One still remained in violation
okay.
at the time of the inspector's inspection.
So the case file as a whole still remained in violation?
Yes,
Okay. And these photographs were a memorialization of that inspection and recorded the property as it appeared the day of that reinspection.
that is correct, yes.
And as the property was still in violation of the code, was a final notice sent to Mr. Ripken?
Yes,
And City Exhibit 8, is that a copy of one of those final notices?
it is. Yes, it is.
And this final notice went to all 4 addresses that the original notice of violation went to?
Yes, it did.
Okay. And as there was no, so eventually did the department discover that the violations had been complied, all 3 of them?
Yes,
And on what date did the department discover that the violations had been complied?
the inspector had went back to the property on April 24th of 2024 and actually complied the remaining violation, which was for the basement window.
Okay. And so then how many, so there was one then reinspection that had failed during the time of that this case was open?
Yes. Yep.
And then, so what is the fee the department charges for the second failed reinspection?
The second failed reinspection is only $100.
$100, okay.
Yeah.
And so then,
That's
City-
when you said that.
I'm sorry, can you keep it down? Someone is testifying, we could hear the conversation.
I'm sorry.
It's okay.
Ms. Fonseca, directing your attention to City Exhibit 9, do you recognize this document?
I do, yes.
And what is this document?
This is pretty much, as it says, a statement of outstanding fees, and that gets mailed to the owner of the property, letting them know that during the course of the re-inspections, there was one re-inspection that failed. So that generates a fee of $100.
Okay, and this was mailed to the petitioner, Mr. Ripken, at 1717 Montrose Street?
Yes.
Okay. And I have no further questions for Ms. Fonseca. And I will stop sharing my screen.
Mr. Ripken, you have any questions for?
I have to can I respond to that information given to me?
Yes.
In no special order, it was said that there was no appeal filed to the city. That's not correct. In fact, I'm sitting here with proof that I filed an appeal, dates and everything, so I'm having the appeals in my hand now. Okay, so I filed it May 21st to 24 is when I filed the appeal.
Are you talking about the appeals to the board?
Right, the appeal to
No,
the
but
board.
they're not, they're talking about an appeal to LNI. It's a
Oh,
different.
That is on that.
This is whatever I'm looking at. It's LNI District. Here's an appeal, LNI District South. When the appeal went, and I'm sitting, not that it's important, but I'm holding the appeal in my hand now. If that matters, I don't know if that matters. Okay, what I think matters is let me challenge some of that information has been not correct. No special order. When the first notice was sent, she clearly said where it was sent to. She said it was sent to 6830 Buist, which is what I said. But I haven't been there in 15 years. She didn't say 1717. She said 6830, which was the same thing that I heard when they challenged me, number one.
I believe she said she sent it to
Well,
4 addresses,
wait, no,
including
no,
seventeen
she- let
seventeen.
me,
Let's
let me
not
say it
talk
again.
over each other, please.
Let me say it again. She was asked where it was sent. And she responded, 6830 Buist. That's what she said. Period. Now, I'm just what I don't. And then she was asked, but she didn't mention any of number one. Number two, I took different notes here. The address is given. I don't even know where Royersford, PA is. Why was you're randomly sending places to Royersford, PA? I've never even heard of it before. So there's some kind of disconnect between where things are being sent anyway, because that's never been my address. I've never been anywhere near Royersford, PA. Okay, now, correct. Once I found out about it and made corrections, I thought I did the things that I did fix were the photographs that were shown were horrible. And the things that I did fix and complied with were those photographs that she picked were the ones that were done. It was the basement windows that were spelled out, the basement windows, and I fixed basement windows. Now, no one was said, I didn't know which basement window it was. There was a basement window in the basement behind a ductwork. I fixed the entire list, and everything was fine, except for a ductwork basement window behind a ductwork, and I didn't know it was there. I didn't see it there, though I did fix 3 windows, and the inspector had to be there to point it to me, and that's why that window wasn't fixed, because no one was able to show me ahead of time. I did my job the best anybody could do, and I never got notice. So the only notice, all she said was that number 3, the third letter, she said the third time went out, it went out to 1717 Montrose is what she said. Bum, 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 bum. I don't know. Yeah. And my case is I never got the first letter, and the NL&I never gave me access to pictures. If I had access to pictures, and I did the best any human being could have done with the cooperation of the city.
Okay.
I did the best anybody could do. I went there, I addressed
All
it,
right.
I fixed everything that I saw. And no one was available to help me find out anything else.
All right. Do you have anything else, sir?
No, sir, I'm done.
Okay. The city, anything else?
Just briefly, I think the testimony of Ms. Fonseca and the exhibits presented today, I think show that the city did act appropriately here. Violations of the Philadelphia Code were observed by the department. A notice of violation was sent, in this case, to 4 addresses. One of those was 1717 Montrose Street, as testified to by Ms. Fonseca. And I would just direct the board's attention to, it was page, I apologize. Page 21 of the city's exhibit packet will show that notice of violation was mailed to 1717 Montrose Street. The appeal, we do not have any record that it was appealed to the board, so those violations are deemed admitted. And so the city did properly re-inspect this location 3 more times. One of those times, they did see that 2 of the violations have been complied. One of them was still uncomplied, meaning it was a failed reinspection, and they are authorized under the code to charge $100 for that second failed reinspection. So we would ask that the petition be dismissed, as the city was properly authorized to charge $100 for that second failed reinspection.
All right. Thank you.
All right, everybody just
My
stay
key.
put. The board is just gonna go back and discuss this matter briefly.
Okay.
Thank you.
Made the car. That's right. Oh, and see them. They're probably in the car. All right. I'm back. Yeah. Hello? I'm hearing nothing.
Your internet went down?
Oh, no.
Boards, they're making their decision in a breakout room. They'll be back soon.
I thought I lost your sound. Okay.
No, they're just, they're deliberating.
So, you know what I didn't get? I never got the date that it was mailed to 1717. Mine was mailed, but there was never any date mentioned that that exactly went to that exact address. Look, I'm worth a lot of money. I'm worth a lot of money. And for $100, I'm just making a point, and it just wasn't fair.
I understand. We just shouldn't, have a discussion while the board's not here.
I gave it a shot. I gave it a shot.
Mr. Ripken, you're moving so much.
Where am I moving? Well, I'm working. I'm trying to get a job done.
You just stay still for 2 minutes while we finish this up.
I gotta get in the car and go somewhere, but I can still have you on the phone.
Yes, of course, of course. Don't drive and Zoom, please.
Are we all back?
Yes, we are
All right,
back.
we're back on the record. Mr. Ripken, the board has decided to grant your petition. Basically, it looks like the first two notices never went to the petitioner. And we believe you as the petitioner acted in good faith. So we're going to grant the petition, find in your favor. What's going to happen now, a letter is going to come out in about 2 weeks to both sides of the issue here, indicating the decision of the board, and also either party has 30 days to file an appeal. That would be the Court of Common Pleas.
Thank you so much. I feel better. It wasn't so much the money, it was the principle. Thank you.
Okay. All right.
Bye-bye.
All right. Take care, everyone.
All right, bye-bye.
We
I
have
think
to,
with that, I'm not sure if we have any other
no, we have to
issues.
confirm it. We have to confirm.
Yes, confirm it, please.
Oh, I'm sorry. Yeah, we have to confirm this. Sorry. Confirmation from members of the board.
George Matthews, I concur.
Nancy Camerdiner, I concur.
John O'Connor, I concur.
Ryan jumped off.
Okay. All right, I guess with that,
that
Melissa, I
everything?
guess there are no other matters before the board today. I think we've had 6 cases, and number 5 is the last of the 6.
Thank you, everyone.
Thank you.
All right.
Bye now.
Okay.
Have a good one.
Take care,
See you
everyone.
later in the
Bye.
week.
Have a good afternoon. Take care.